Now, I think.
Oh no.
Yeah,
There
it's
you go.
recording now.
Okay, thanks, Mine. So thank you for joining us for this recorded webinar. What we're doing is we want to answer some questions for prospective pupils. We are advertising at the moment for a pupil hopefully to start in October 2026, although that date can be flexible. Hermione is one of our junior tenants and Andrew is our current pupil, and they've been approached with some questions for prospective applicants. So we thought rather than take up their time answering these questions remotely, we thought we'd do a bit of a Q&A for you so you get an idea of what the civil team is like, what pupils have to do, and what life as a junior tenant's like. So a couple of questions that have been written for me, I'll set us off. So the type of work that a pupil will see over the year, well, you'll have hopefully had a look on our website and see the work that we practice in, and that is genuinely the work that we all take part in over the year. We're a fairly small team, and as a result each person has taken on a bit of a specialism. So for example, you may have noticed I do a lot of Talata work. I do around that quite a bit of contracts, general civil disputes and employment as well, and probate. Whereas you may have seen someone like Laura Smallwood has specialised more in landlord and tenant and property related disputes. So there's a lot that we do, but how we operate that is by having pupils go with different people each week, depending on how busy each practitioner is and how much they're in court. One of the questions was how often a pupil will be in court, for example, and how much advocacy they will actually see. We very much focus on trying to get pupils into court as much as possible. Almost every day somebody is in court. But if, for example, there was a particularly good case, a 3, 4, 5 day trial, then we'd offer that to a pupil. Likewise, if it was further afield, Hermione was reminding me that he came to Bristol with me on a 5-day trial in his first couple of months. Now, while of course that is an opportunity available to a pupil, we don't expect people to travel if they don't want to and it's not convenient for them. But there is a lot to see, and Andrew and Hermione will talk a bit about that in a moment. I've also been asked about feedback and support a pupil can expect. So what we do is we have each civil practitioner will set at least one piece of written paperwork for the pupil to do. And again, that is in a structured way where it will be stages of here's the piece of paperwork, and it will usually be a piece of work that tenant's been given already in the past. They will set, for myself, for example, I will want to see the type of preparatory work that a pupil's done, see what cases they've identified before they embark on, if it's in advice, for example, make sure they're on the right track before spending a day or two doing a piece of work. Then there's a structured feedback form, and there's also an oral feedback session where it can be discussed. For example, if the pupil thought that it was one answer and you'd given a different one, you can discuss that and make sure that you're happy with the feedback. We then also have a mock advocacy exercise that we set in chambers with various actors from the tenancy team, and then we try and come and watch pupils in their second six as well. So there's structured feedback both in first six and in second six, and obviously with an opportunity to give your own feedback about that. Final point I've been asked is about applicants, and obviously we have an academic criteria. I've been asked, what are you genuinely looking for in a candidate? Well, I'd say probably the first thing is to have confidence in your own ability, but recognition that pupillage is about learning. We don't expect people to be, straight away on their feet, an excellent advocate and brilliant paperwork. So just appreciating that there's a lot to learn, but also having confidence in yourself and, having a personality of your own. And part of that also is being able to ask for help and not feeling that any question you ask is going to be judged. It genuinely is a real learning experience, and I've never been asked anything by a pupil that I've thought was inappropriate or that I thought they should have already known. That there literally isn't any question that would be too silly or too small. And then the final thing is about being proactive in your practice. looking at opportunities for yourself, looking at pro bono options, asking to do something, asking to do an article, speaking to the clerks about, I wouldn't mind going further afield. I haven't seen any employment work, that kind of thing. Making clear what you want to see, especially after the first 3 months, and offering, to help when you can on both research and, attendance notes, things like that. So that's my bit. Hopefully haven't kept you too long. And then we're going to, was there anything, Hermione or Andrew, that you wanted to add to that before we move on?
Just the pupillage learning experience. I know we were talking about it just before the call started. I think there's a real emphasis, I think, at Guildford Chambers that you will come in, and a lot of people, I think, come in straight from bar course potentially. You come in, you learn, and at least one of the things that I think a member of Chambers told me was, look, the book is completely different from real practice, and so you're going to have to learn a lot of new things. For example, how to deal with clients, how to make a certain submission before a judge, especially, for example, submission which may not essentially hold that much weight, but to a client, for example, it may mean everything. And so a lot of that comes down to purely learning, and you can only really learn that once you come in with a very open mind that, look, pupillage as a whole is a learning experience, and I'm here to learn, I'm here to develop, and essentially develop not just as a pupil but as a person overall, because there's a lot of interpersonal skills which you will develop, I think, as a pupil. And there's a real emphasis here that, at least it was when I was doing pupillage, that, for example, if you have a question, if there's something that you just don't feel, for example, particularly strong about, or for example, if you're drafting a skeleton of some sort, send it across to some member of Chambers, ask for their feedback. And for example, it changed my view so much that when I was doing my bar course, I'd be quite hesitant to share, for example, a skeleton to ask for views from somebody. But versus now, I will happily email a member of Chambers and say, look, this is my skeleton. Am I on the right track? Is there something that you would wish for me to develop on? And of course, that's me now as a tenant as well, not just me as a pupil. And so it's really all of that in practice more than anything else. But I think Andrew had something to say about that too.
Did I?
But you're shaking your head, so I was thinking you may add something.
No, I'm not. I'm nodding in agreement. I think I'll save my comments. I think I have similar questions coming up, so I think I don't want to step on my future toes.
Sure. Thanks, Andrew. So the first question I think we had for you was how you found the jump from bar course going straight into pupillage.
Yes, well, I had a little bit of a gap between bar course and starting pupillage, so I didn't have that direct crossover that Hermione was just talking about. I had a bit of time working as a paralegal, and I also did county court advocacy work as a solicitor's agent, which I think helped to make the adjustment a little bit easier in that I knew what to expect. I'd appeared in front of a district judge before, but to Hermione's point, I mean, there is a lot that you don't learn on the bar course or in bar school. There's nothing like practical experience for just understanding not only the skills that you need to bring and how you need to be doing your advocacy for specific hearings, but just the feeling of being in the hearing and all kinds of small things that you would never think to prepare. But I'll keep that secret. I don't want to give all the game away.
So how would you say, if at all, your first 6 differed from what your expectations were?
Well, personally, I think I'd heard a lot of horror stories about pupillage and people's experiences, staying up late and working to death and waking up at 4 a.m. to get on top of that kind of stuff. So I think that pupillage at Guildford Chambers differed from what I sort of feared, in that it was a lot more manageable in a good way, as in everyone was very conscientious about my workload, about not swamping me with stuff in a way that would dissuade me from committing to the bar as a career. So I felt I felt people were very accommodating and welcoming to me, and it's worked out a lot more manageably than I had feared.
Okay, good. And in terms of those first couple of months, what kind of things were you doing, both in court and in paperwork?
So as you mentioned, Rowan, there was obviously Chambers has its practice areas, which you can probably imagine from, well, if you've seen the website, you'll see. So, and as you mentioned, while we do have supervisors and we do have individuals who are in the tenancy team who are in charge of me every month, um, obviously as a relatively small team, I was assigned, I was shadowing people who had interesting things on a day by day basis. So just as a flavor, I saw plenty of things. I saw personal injury. I saw a personal injury appeal. I saw a lot of different property matters. I shadowed you, Rowan, in various Talata matters and employment tribunal stuff. That was a bit different to go to the employment tribunal, bit of a different flavor of things. Again, property related things. I saw injunction hearings. And as I got towards the back end of first six, the clerks were very mindful to give me experience in the kind of things that I would be doing in my second six. So I was with Hermione a lot. I saw a lot of small claims, road traffic accidents, that kind of thing, and civil applications just to prepare me for what I was going to be doing in a month or so.
Okay. And is there anything that you found particularly challenging or particularly rewarding in that period?
Well, I think the transition from shadowing during your first six to actually having to do it yourself is obviously going to be challenging. Even notwithstanding the amount of support that I was offered, which obviously I was given a huge amount of support. But I think your first day, your first hearing is always going to be stressful, even if it's a 10-minute possession matter. It doesn't matter. It's going to be stressful. So I did find that challenging. I was actually on holiday in Cornwall for a few days, and just before I did my first hearing, and those last few days before the hearing was, there was a lot on my mind. So I really had to prepare a lot for that hearing. Ultimately, it was fine. It all went according to plan. And actually, once you get over the hump of that feeling nervous about it, 6 months is a lot of time to learn a lot from observing everyone else. And by the end, as you get towards the end of the second six, of your first six, hopefully you'll feel ready to, and I know I did, feel ready to get up there and do it yourself. Um, so I guess, yeah, what was challenging was the stressful nature of it, but that also makes it rewarding. But in terms of specifically rewarding things, I have got a lot out of providing work for people who really care about the outcome of their claim. And yeah, I mean, helping people navigate even to something which hopefully to us, as we get more experience, or as I get more experience, I'm sure to you guys, dealing with the kinds of claims we deal with on a daily basis is not necessarily a particularly stressful matter for us. But for people coming to court, it's probably their first time in court. They're probably extremely nervous about what will happen. And they probably don't know anything. Like I've had people ask me, and I know, Hermione, you've had a similar experience where people have been like, what is going to happen? Can I get in trouble today? No, it's a small claim RTA. You're going to be fine. So just being aware of that and being in a position to help people navigate a really difficult and stressful experience in their lives and hopefully get them a good result. I think that's been very rewarding.
Okay, thank you. And how often, if you're able to say, in a given week, would you be in court, and have you had any, written paperwork to do in your second six?
Yes. So it depends week by week. I would say as an average, it's probably 3 to 4 times a week. I've had some weeks where I've had something every day. And I think that's, again, a good selling point for Chambers. You will get a lot of court time. You'll get a lot of oral advocacy experience. You'll have a lot of opportunity to be in front of judges and to learn on the job, to figure out what works and what doesn't work, which I think is really, really valuable. In terms of written work, I've had a few instructions already during my second six. So I did a response letter for a Talata matter, pre-issue, and that was quite fun. That was good to go back and forth with the solicitor and figure out what was going on. And then I am currently working on an advice on quantum for a personal injury matter where a child was injured at school. So that's also been quite interesting and provided a lot for me to get my teeth sunk into. So there's plenty of work during your second six, so I wouldn't be concerned about that.
And have you managed to fit in anything else? I know you've looked at pro bono work and that kind of thing. Have you done any of that yet?
I have, yes. So I've taken on a couple of different pro bono stuff. A lot of that is ongoing. I thought that it was going to be finished relatively quickly, but I've been saddled with various things, which is great because that's giving me more opportunities. So I've taken on a small claim contract dispute. I've given some advice to somebody who had an application hearing coming up. I've got an employment tribunal preliminary hearing coming up next week. And I've also got a sort of probate, sort of commercial lease advice situation, which I'm trying to track my client down for that. And Chambers has been very supportive and allowed me plenty of opportunities to take on pro bono work, which I think has been really great. And that's also a good experience for obviously I'm not qualified for direct access, but doing pro bono through advocates, it's like having direct access experience where you don't have the intermediary of a solicitor. You get to interact with your lay client directly for good or for ill. And yeah, I think it's really taught me it's provided me insight into the process, which I didn't have previously in as much depth. So, for example, with my contractual client, she just emailed me this morning. Her opponent has uploaded a defective witness statement, and now the question for me is, what should we do about it? So, it's provided me plenty of different looks into, different aspects of the litigation process. So yeah, it's been very, very rewarding.
Okay, thank you. I think the last point really for you is a kind of practical one. Obviously, we know you live in London and Chambers is in Guildford. So, how are you finding that? Do you have to be in Chambers every day? How does it work in practice? That kind of thing.
Thanks, Ryan. Yeah, that was something that before I started, I was actually a little bit worried about. But in practice, it's been totally fine. I am not, and this is important to stress, I think it's a good selling point for Chambers. You're not expected to be in Chambers every day. As you said, we're a small team and people aren't necessarily going to be in Chambers themselves. So as the pupil, you are not required to traipse into Chambers every single day. Obviously, it's good during your first six to come into Chambers to get to meet people, and that is obviously encouraged. But there's no, gun to your head, forced to come in every day like I know some other places do. In terms of convenience, I mean, as you say, I live in London. I have not felt like I've been inconvenienced by not living in Guildford. I'm not actually in Guildford that much. I mean, I don't know about you guys, but occasionally I'm in Guildford. Most of the time, I'm at various courts, London courts, Reading, or further afield. Sometimes I've been to Portsmouth or even Bournemouth, places like that, where I have not really felt like I've been disadvantaged by being in London instead of Guildford. So I would say if you live, I mean, it might be difficult if you lived in Leeds or somewhere, but if you are in roughly the correct area, it shouldn't really be an issue.
All right, thanks, Andrew. We're going to move on to some questions for Hermione, but if you want to add anything at any point, please do, or if you've got anything that you want to ask him. So Hermione, how long have you been at Chambers and how has your practice kind of developed since you became a tenant?
So I think I started my pupillage in September, October 2023. Of course, then did pupillage and then got tenancy and stayed on pretty much. Practice it's quite literally gone on an upward scale, if I can describe it as that, because when you're a pupil, I think you do a lot of RTAs. Even as a tenant, as a junior tenant, you are going to do a lot of small claims, etc. And to be honest, they really do help you build your practice. One of the things I always say to people, at least to many people, and one of the things I've been saying to Andrew actually, is that the same principles that apply to a £500 claim will also apply potentially to a £5,000 claim. They may as well apply to a £500,000 claim. And so once you're in court, for example, as a pupil, you will get to see, for example, being in court every day, cross-examining somebody. And even for these small claim theories, for example, you may be cross-examining somebody on fundamental dishonesty, etc. But you are learning on the job because it's a way you ask those questions, it's a way you essentially build that case, and you come in for that ultimate blow. And of course, you learn that, and then of course you'll do your fast tracks, you'll potentially do your multi-track. The best way to demonstrate in terms of like how practice has evolved, essentially, I do a lot more drafting now, a lot more paperwork, a lot more advice actually. So quite recently I've drafted defenses for contract claims. I was doing one recently about a business dispute between partners, £300,000 claim where I'm just drafting a defense. And again, I did a lot of that, of course, at a much lower value as a pupil. And again, the principles I learned when I was a pupil was, for example, because you're drafting a defense, go back with a lay client, work with them, think through the arguments that are potentially going to come out at trial, and try and think prospectively, not just thinking essentially backwards. So I've done that. I'm also currently drafting, and I think I'm meant to send it off tomorrow. So maybe a longer evening today in terms of work, but drafting an injunction application for a boundary dispute. I'm also drafting an urgent advice for a High Court matter. About 2 weeks ago, I was in the RCJ again in the King's Bench division, I think they call it, where I was a Part 20. Well, I was representing the Part 20 defendant, and one of the things we were arguing about was we shouldn't be part of these proceedings, etc. And even for something like that, my clients, they had got a default judgment entered against them worth a considerable amount of money. We're looking at well over £1 million once you take in costs and everything put together. But again, for something like that, the building blocks of us succeeding on that application, I think, came directly from my pupillage. The principles I learned during pupillage, of course, I developed them further on, etc. And a lot of that didn't just come from, for example, members of chambers, but that came, for example, through my clerks, who almost bring you that human touch in terms of explain, look, if you have a client, you need to have conversations. This is how you potentially have them. And I think that's where Guildford Chambers really shines. I think we only have now three clerks, but you will call them and they will recognize your number straight away and be like, oh, look, how was it? And you could think you've had, for example, a bad defeat, for example, and you've lost quite badly, and they're like, look, nothing to worry about, move on. This is how you deal with it, etc. going forward. And I really like that aspect of it.
Okay. And so that's kind of an overview of how your practice has developed. How often would you say you're in court these days?
So next week I'm in court 5 days, I think. But this week I was only in 3 times. The week after I'm in 4 times. I think the general rule of thumb is you usually in 3 or 4 times. I think it works a lot better in practice. I sometimes say, look, I'd rather be in court 10 days, like every single day, like 7 days a week. I'll happily do that. But again, it depends on the severity of work. So, for example, next week is going to be quite a difficult week potentially because I've got 2 fast tracks. So again, that requires a lot more preparation. I could very easily have just done 2 of those fast track cases. So I think it depends on the time period, but yeah, you can, I think, expect to be in court 3 or 4 times a week, and then of course you will have your own advice drafting or something to do on the side, and be quite strong on that, I think.
So on that point, you said you could have easily had 2. If you'd felt 3 was too many, could you have asked for somebody else to cover the 3rd one? Is that what you were saying?
So for example, I think it goes back to, I think, one of the questions that Andrews was answering in terms of how accommodating Chambers is. When I was a pupil, I got really badly injured and I hurt my knee. I remember complaining to you about it once, like, oh, I've hurt my knee, etc. Chambers was very accommodating to say, look, you have these cases. For example, if you're going for a physio appointment, somebody else can potentially take them, and that's what ultimately happened. And then when I was having some work done on my knee, again, same thing. I was meant to have a case on, I think, a Wednesday, 1 week, and then on the Fridays when I was having surgery on my knee, and I very easily passed it to somebody else in Chambers on a Monday morning because I was like, there's no way I can do it. But there is that. I know, for example, if I have something quite urgent. So, for example, even in that case I was doing at the RCJ 2 weeks ago, there's a possibility that it might spill over into the next day. Or it might spill over to some other day. And I had the conversation with the solicitors and my client that, look, we will be able to fill it into my diary. I know somebody will be able to take a case. I've certainly done that on more than one occasion in the past. I know other members of Chambers have needed, a case forwarded to me, for example, and I've simply taken over.
All right, thank you. And what about, I know you've been asked about pro bono initiatives, CPD, training opportunities, events and seminars, and how you have experienced that in Chambers and what opportunities there have been. Can you help us with that?
So in terms of pro bono, I think just goes back to I think what Andrew was saying. There is a real emphasis to do pro bono work. I certainly did a lot of pro bono work when I was a pupil. I still do it. In terms of CBT, well, CPD initiatives, etc. I know there was we did a couple of seminars as members of Chambers, and I kind of tried avoided doing the seminar myself. But yeah, there's a real emphasis, and I think I'm gonna, of course, I can put that in my own diary that look, I attended this seminar on this day at my own Chambers. But there is a real emphasis that look, it's your own practice, you develop it, you take the lead on it. And for example, you sit down with your clerks and you have the conversations in terms of, look, this is where I potentially want to go in terms of career wise, in terms of practice area, for example, and say, look, this is the type of cases I want. This is something I'm really good at, and and they will work with you on that. So, for example, at the start of the year, I had a conversation because of senior clerk Simon, where me and him were just running through practice, essentially a practice review, where he's saying, look, you're really good at this. I think you should develop this aspect more. And one of the things I said to Simon was, look, it may be that I come back to you in a couple of months when I've thought about this more and I've actually had an opportunity to develop on it. And I think we're going to have a meeting in about a couple of weeks, just to discuss that even further.
Okay, nice. And in terms of practicing in Guildford rather than in London, obviously you've heard what Andrew said. Just, I know you've been asked about how much you have to travel and why you chose Guildford rather than looking at a London set. Is there anything else that you can add to what you've heard?
Yeah, so when I was applying for Pupillage, so many years ago, of course, I had the choice of, look, choose a London set or choose somewhere on the outskirts. One of the main reasons where as to why I was attracted to Guildford was it's just an arm's length away from London. Just jump on a train and you can just head into London and do a hearing there. I'm certainly in London quite a lot more now, I think, than I was a couple of months ago, for example. I really like that aspect. I feel like it's a bit, everything is a bit more relaxed. It does mean, for example, that sometimes, for example, my opponents in court sometimes seem to be the same people, and I have that some sort of friendship with them, etc. To say, look, it's the same person. I know how they argue certain things. Ask them how the day was. One of the harshest things I think in this profession is you end up being quite lonely in the sense that you will end up you pretty much on a daily basis going to different parts potentially of of an area in front of a different judge arguing for completely different clients, etc. Being established somewhere such as Guildford really does help. I know, for example, when I've had certain cases in Guildford before a particular judge, I've just messaged somebody from Chambers and said, look, what do you think of this judge? Is this something that I should emphasize, for example? And we do, okay, look, this judge, for example, likes arguments like this, or you may, for example, wish to develop on this point. That really does help. Plus, with London, I think it's just too hectic for me, I think.
Okay, thank you. That's really helpful. So I think the last point to close things off is, I mean, you could both answer this if you like, but looking back now, what is it that you wish you'd known when you applied, or looking back, is there anything that you could help give advice to somebody applying, that kind of thing?
Andrew, why don't you go first?
Oh, sorry, I muted myself. I don't think my advice is going to be anything less than a bit generic and stuff that people probably have heard before, but it is true. I think in terms of advice for people applying, I think what Chambers wants to see is that you understand what you're signing up for, in a good way and a bad way. You understand what the profession is like, you understand what daily life is like, that you understand Chambers and you can show why you're specifically applying for Guildford Chambers. You're not just, applying to 20 places and Guildford is one of them. And you can express reasons why you would do well at Chambers. I think if you can fill those in, And another an aspect of that last point, I think, is also that we can get a sense of your personality as well, because we will be spending a lot of time with you, and if you're not nice, then we don't want to spend time with you. So don't be afraid to show your personality a bit. And I think if you can tick those boxes, if you can show us who you are, that you know the profession, you know Chambers, and that's why you're applying, then I think you'll be in a really, really strong position, and you've put yourself in the best possible position. And then it's just up to you to perform at interview.
Sure. I mean, I didn't know you were going to say that, and I would endorse that answer. So thank you. Hermione, in terms of anything you wish you'd known back then, or anything else that you can add?
I think prep more than anything else. Again, I think it goes without saying, you're ending up before, for example, a judge. You're raising your client's perspective, for example, raising their case, etc. You should be able to prep to a point. For example, if something pops up, page 610, for example, you should think, okay, it's near the end of the bundle, be able to find it and have the confidence to be able to do that. I think I really struggled with that right at the very beginning, where I would think, okay, where is it? Like, I know there's an answer here. And we did an assessment, I think, in my, just before my second six started in Chambers, where I was cross-examining you. I think you were the witness.
Possibly. Yeah.
Yeah, you were the witness, and you said something in a cross-examination answer, and I knew it was wrong. I just knew it was wrong, that it wasn't in the paperwork, etc. And it was just about, okay, but where is it? Where is it in the paperwork? And just having the confidence to turn around and say, just pause and take 5 minutes, and to be able to quite literally go through the page and be like, no, it's on this page. But I think just if I had that, for example, just when I was applying, just that mindset that, look, people are relying on you. Yes, this seems like quite an audacious process, quite a difficult process in terms of getting pupillage. But the whole point is that people are going to be trusting your advice, essentially your effort and your work and your advocacy skills for things which will affect their lives. Of course, for example, if you're on the criminal side, yes, somebody might be going to prison, might be losing their time, etc. Same thing with the family side, somebody might be losing their kids or access to their children. But even on the family side, £10,000, for example, makes a huge difference to somebody's life. They're trusting you with that process, have the confidence to be able to, give advice and be able to justify it. I just wish I understood that as a concept more prior to, for example, applying and just jumping in, for example, into first six and second six, that, look, people are trusting you, at least have the ability to trust yourself, for example.
Okay. All right. Thank you both so much for your time. I know, Hermione, you're rushing off to court as well today, aren't you? So thank you very much. And obviously, if there is anything that we've missed, or if anyone does want to ask anything else more specific, please do get in touch with any three of us. Thank you for your time. Bye.
Thank you.
Thank you. Bye.
I think